Let's talk about possession of a controlled substance in Texas. You might think possession of a controlled substance is a pretty straightforward concept. You either had drugs on your person or you didn't. Turns out the reality is much more complicated. First, let's talk about possession. Possession in Texas means the care, custody, and control. So for example, I can be charged with, let's use my pen as an example, possession of a pen that is actually in my pocket. If I go set it on a table, it's still in my possession because it's in my care, custody, and control. It doesn't have to be on my person. In fact, I could leave it at home, be at work, and if no one else has access to my home, I'm still in possession of that pen that's at my residence. So possession is a much broader concept than most people would think of when they think of possession, and that's important to understand. Additionally, and pardon the pun, but we have something called joint possession in Texas. That means I can have possession of something and my wife can have possession of that same thing at the same time. So for example, if we share a car, I can be in possession of the car and she can be in possession of the car. If it's under our care, custody, and control, we're legally considered to have possession, even though physically I may have the car this morning. So how does all of that work into a drug charge? Well, imagine a scenario where you get into a car and your passenger brings drugs into the car. Now, there are some circumstances where your passenger might have exclusive possession of that item or the drugs. For example, if you didn't know the drugs were in their possession, if it's on their person or on something that's very specifically theirs. So for example, their purse and you have no access to their purse. Then there's a strong argument that you did not have possession, not even joint possession, of those drugs. However, if the passenger gets in your vehicle and takes the drugs out, puts it in the center console, into a passenger compartment in the door, well, now you might have possession of that under the law in Texas. This means a police officer can arrest you for something that your passenger brought into the car and placed into your vehicle. So joint possession has some very real consequences. Imagine a scenario where you are a roommate and there are multiple people that live in a residence. Something found in a common area can be attributed to you even if you've never actually possessed it. Remember, a police officer can arrest you just based on probable cause. That's a low level of proof. Of course, there will be a separate question of whether or not the prosecutor can prove that case beyond a reasonable doubt. But at that point, you've already been arrested, you've spent some time in jail, you've bonded out, and here you are defending a criminal case. So the big takeaway in regards to possession itself is it doesn't have to be on your person. Think much more broadly. Be careful about who you're around and who might be getting into your vehicle or whose vehicle you might get into. Broadly speaking, there are 9 penalty groups in Texas. Some have numbers, and then there are 2 at the end that are kind of their own penalty groups. So you have penalty group 1, 1A, 1B, which is the newest category. You have 2, 2A, 3, 4, possession of a dangerous drug, and possession of marijuana. When we talk about the classification of drugs, we're talking about essentially a spectrum. On one end of the spectrum, there are drugs that have little to no medical value, or their risk of addiction or their effects on the human body are so profound that they greatly outweigh any normal medical effect it would have. On the other end of the spectrum, we have drugs that you can obtain fairly easily with prescriptions and are just controlled substances. They're not nearly as addictive and they're not nearly as harmful or have that potential harm that some other drugs might have. Penalty group 1 is the most serious. Penalty group 4 is generally the least serious. And as we talk about the penalty ranges for these offenses, you will see that the penalties for something in penalty group 1 is much harsher than something in penalty group 4, and it is very much a spectrum where the higher the penalty group, the lower the seriousness of the charge. Here's something else that's interesting about controlled substances in Texas. Most people would imagine, in fact, most attorneys would imagine, that the controlled substance schedules are determined by the legislature. And that's partially true. The legislature gives the Director of State Health Services the ability to add drugs to any category and to amend the list. So as new drugs emerge, particularly when we're talking about analogs, which is a chemically unique or different version of a already existing drug, the director has the ability to go in and add that to a penalty group. That comes as a surprise to most people that you have one individual in the state of Texas that can go in and make something illegal. Perhaps the reason behind this is our legislature only meets every 2 years. So this gives law enforcement an opportunity to go after something before the next legislative session. Yet citizens probably are not aware that a single person in our state has the ability to do this. So let's talk about the penalty groups. We'll talk about the drugs that are contained in each penalty group, as well as the punishment ranges that you'll see if you're charged with this type of an offense. Penalty group 1. Penalty group 1 substances make up the most serious offenses in Texas. For example, having under 1 gram of a penalty group 1 substance is already a felony offense. In Texas, that's called a state jail felony, which is punishable by a minimum of 180 days in jail up to 2 years in jail. So what drugs are so serious that they fall under penalty group 1? Typically, these are drugs that have no medical purpose and have a serious effect on the human body. That would include things like heroin, cocaine, whether that's crack cocaine or regular cocaine, methamphetamine. It also includes things like ketamine, oxy, GHB, and hydrocodone in large quantities. Now, you'll notice some of these substances have a medical purpose, yet the effects on the human body are so significant that these drugs have been classified as penalty group 1 substances. We talked about an under 1 gram case being punishable as a felony. If you have 1 to 4 grams, that's a 3rd degree felony, punishable by up to 10 years in prison. If you have 4 to 200 grams, it becomes a 2nd degree felony. That's punishable by up to 20 years in prison. If you have 200 to 400 grams, now you're looking at a sentence of up to life in prison. 5 years to 99 years or life in prison. So what if you have over 400 grams of a penalty group 1 substance? Now understand, 400 grams by its definition is under half a kilo. And in some circles, that's not even a lot of weight. Yet in Texas, that carries a punishment of 10 years to life in prison. Now the 10-year portion of that has significance because you cannot get a probated sentence, meaning a jury cannot give you probation if your sentence is more than 10 years. The 10-year minimum on this type of offense is significant because a prosecutor is going to know that a jury will generally not be able to probate your sentence. Sentences in excess of 10 years can't be probated by a jury, which will mean the prosecutor is going to play hardball. The negotiations will be much tougher if you're facing that highest penalty range for a penalty group 1 substance in Texas. Penalty group 1A is reserved for a very narrow category of drugs. Penalty group 1A specifically relates to LSD, acid, or any of its analogs. An analog being something that is chemically similar in composition and in effect to LSD. LSD is in its own category, one, because of the devastating effects that LSD can have, but also because of how it is measured. It's measured by dose or unit. So for example, if you have fewer than 20 units of LSD, that is considered a state jail felony, punishable by up to 2 years in state jail. If you have 20 to 80 units, that's considered a 3rd degree felony, punishable by up to 10 years in prison. If you have 80 units or more, but less than 4,000 units, that's considered a 2nd degree felony in Texas, punishable by up to 20 years in prison. If you have 4,000 to 8,000 units, that is considered a 1st degree felony in Texas, and that's punishable by up to life in prison. If you have 8,000 or more units of LSD, that's considered an enhanced 1st degree felony. And in Texas, that particular offense is punishable by 15 years to life in prison. Once again, because the sentence is over 10 years, the prosecutor knows a jury cannot give you probation, and therefore those negotiations will be very difficult. The newest penalty group is penalty group 1B, and that is reserved for fentanyl. Fentanyl has been given its own punishment range, and in fact, it has the highest possible punishment of any drug in Texas. Under 1 gram of fentanyl in Texas results in a 3rd degree felony charge, which is 2 to 10 years in prison. Texas created this new category to create a higher level of punishment because of the devastating effects that fentanyl, even in very small amounts, can have on the human body. The unfortunate truth is we have all seen deaths related to fentanyl, even in very small amounts, and even in individuals who had no idea what they were taking had fentanyl in it. Unlike any other drug in Texas, it's not a true stair step from the lowest level offense working your way up the punishment ladder. 1 to 4 grams of fentanyl jumps from a 3rd-degree felony to a 1st-degree felony. So 1 to 4 grams exposes you to up to life in prison in Texas, a minimum of 5 years to 99 years or life. 4 to 200 grams becomes a 10-year minimum to 99 years or life. 200 to 400 grams becomes a 15 to 99 year or life charge in Texas, and over 400 grams of fentanyl in Texas at the state level, so we're not even talking about federal prosecution at this point, carries a minimum punishment of 20 years in prison up to life in prison. That is the highest punishment range for any drug offense in Texas. Penalty Group 2 substances are drugs that are less dangerous than Penalty Group 1 substances. Nonetheless, they still carry significant punishment ranges. Penalty Group 2 substances include things like MDMA or Molly or ecstasy, Adderall, PCP, peyote, psilocybins, or mushrooms. And yet in this same category, you see things on the far end of the spectrum, such as THC. As you look at the substances contained in Penalty Group 2, you will see that the legislature intended to punish some things more harshly than others, and there's really not the underlying difference in harmfulness that you should expect when you're looking at the different penalty groups. No scientist is going to argue the effects of THC are the same or nearly the same as PCP. And yet in Texas, you see them both classified in the same penalty group. In fact, Adderall, something that almost anyone can get easily through a prescription, is considered a Penalty Group 2 substance in Texas. So let's talk a moment about prescription drugs. You can certainly be charged with prescription drugs as a drug offense in Texas under certain circumstances. The first is obvious. You have some drugs that were not prescribed to you, they've never been prescribed to you, and you shouldn't have them. And that's probably what you're thinking of when you think about a criminal charge for prescription drugs. Yet you can also be charged with possession of a prescription drug if you're not carrying the prescription in the bottle that you received it, that has the labeling that says it was made out to you and it's still a valid prescription. Most people carry their daily use prescription medication in a variety of packages. They can throw it into their purse, other belongings, into their pocket, containers and carriers, and all of that seems very normal. Yet the wrong police officer may make a decision to arrest you for a drug that you have actually been prescribed, and it'll be on you to go to court and prove that you had a valid prescription at the time. It's not an automatic defense. Most prosecutors will ultimately dismiss a case under those circumstances, but it's worth pointing out you need to carry your prescriptions in the prescription bottles and only carry them while those prescriptions are still valid. The punishment range for Penalty Group 2 substances start at a state jail felony. So if you have under 1 gram of a Penalty Group 2 substance, that is punishable by 180 days to 2 years in state jail. 1 to 4 grams becomes a 3rd-degree felony, punishable by up to 10 years in prison. 4 to 400 grams becomes a 2nd-degree felony, punishable by up to 20 years in prison. And over 400 grams becomes a 1st-degree felony. That's punishable by 5 years to 99 years or life in prison in Texas. Penalty Group 2A is another narrow category, and it contains synthetic cannabinoids. So these are chemically produced products that are meant to mimic the effects of cannabinoids, but they are not cannabinoids. So an example of that would be K2 or spice. The punishment range for Penalty Group 2A substances are very similar to that of marijuana. So for example, under 2 ounces of a Penalty Group 2A substance is going to be a Class B misdemeanor, punishable by up to 180 days in jail. 2 to 4 ounces is going to be a Class A misdemeanor, punishable by up to a year in jail. 4 ounces to 5 pounds is a state jail felony. 5 to 50 pounds is a 3rd-degree felony. 50 pounds to 2,000 pounds is a 2nd-degree felony, and it becomes a 1st-degree felony once you have more than 2,000 pounds of K2 or spice. Penalty Group 3 contains largely prescription medications that are, for the most part, either a stimulant or a depressant. There's a long list of substances that are contained within Penalty Group 3. They include things like Valium, Xanax, clonazepam, diazepam, hydrocodone in smaller doses than we talked about for Penalty Group 1, codeine at low dosages, lorazepam, Ritalin, testosterone, which is actually a common one, and HGH, or the human growth hormone. One way we see penalty group 3 cases filed in Tarrant County include individuals coming back from Mexico where they obtained drugs either with a prescription there or no prescription. They come back and either due to the lack of prescription, or they didn't keep a copy of the prescription, or just that the U.S. authorities did not accept what they had as a prescription, you'll see individuals getting charged with penalty group 3 substances. They're not the most serious of offenses because we at least have a misdemeanor version of this offense, but they're still serious, and many of the individuals who are charged under these circumstances may not have realized what they were doing was criminal, and likely they have no criminal history. Under 28 grams of a penalty group 3 substance is a Class A misdemeanor in Texas, so it's punishable by up to 1 year in county jail. 28 grams to 200 grams is considered a 3rd degree felony, and that's punishable by 2 to 10 years in prison. 200 to 400 grams becomes a 2nd degree felony, so that's punishable by up to 20 years in prison. Over 400 grams of a penalty group 3 substance becomes a 1st degree felony with a punishment range of 5 years to 99 years or life in prison. Penalty group 4 substances include prescription medications that have the possibility of being abused. These include drugs such as opium and morphine. Once again, you can see the legislature's choice in placing different drugs in different categories. Some might argue there are things that are in penalty group 3 that are more addictive and more harmful than the substances we talked about in penalty group 4, yet penalty group 4 is the lowest of these penalty groups. So the punishment range begins at a Class B misdemeanor. Under 28 grams of a penalty group 4 substance is a Class B misdemeanor punishable by up to 180 days in jail. 28 grams to 200 grams is a 3rd degree felony punishable by up to 10 years in prison. 200 to 400 grams is a 2nd degree felony punishable by up to 20 years in prison. And finally, over 400 grams is a 1st degree felony punishable by 5 to 99 years or life in prison. If you're charged with a possession charge in Texas, it's important to contact an attorney. Depending on your jurisdiction, there may be a number of options to try to resolve the case favorably. Favorably for me and my firm means we want to avoid a conviction, whether that's a felony conviction or a misdemeanor conviction. We certainly want to keep you out of custody, whether that's jail or prison. And ultimately, if at all possible, we want to do something that will protect your record. Meaning, is there a pathway for a non-disclosure in the future, which would be a sealing of the entire criminal record, including the arrest, or even an expunction, which would be the deletion of every record associated with your case. There are a number of ways to achieve this. We could point out weaknesses in the case. We could argue about whether or not there was a proper stop or search, or if the evidence was tested properly. There might also be diversion programs that we can get you into that could lead to a dismissal of the charges outright. There's also a category of low-level drug offenses for which a first-time offense cannot result in state jail time, prison time, or ultimately you going into custody. Yet not everyone knows this. Certainly most prosecutors don't know this, and I would venture to guess that many defense attorneys don't know this. So be sure you contact an attorney that has a lot of experience handling drug cases, challenging drug cases in court, and successfully defending these charges. If you've been charged with a drug offense in North Texas, give us a call. We can help. Our number is 817-203-2220.